Good afternoon, sir.
Good afternoon, boss.
Uh, Sir,
Let
shall
us
we
wait
begin
for
today's session?
4-5
Yes, sir.
minutes. Then start.
Yes, sir. Shall we begin today's session, sir?
Yes, yes.
So today's session is basically between the line strict versus liberal interpretation in GST. In today's session, sir will be enlightening us about how the approach is with respect to tax laws. So, sir, starting off, why strict interpretation considered essential in fiscal statutes, and what constitutional provision underpins this requirement of the same?
See, constitutionally speaking, Article 265 uh, provides that no tax can be levied except without authority of law. So the concept of strict interpretation flows from there, that there must be a very clear categorical law to exact tax from the citizens. Now, the purpose behind the strict interpretation of the law is that it saves the citizen or the SSE from the any arbitrary action of the tax officer, so that even if the letter of the law, from the very plain, unambiguous, clear reading of the law, the tax is not leviable, even then, by implication, the tax may be levied. So that is the purpose of the strict interpretation.
So now that we have an idea about what strict interpretation is, could you tell us a little bit more about what literal interpretation and liberal interpretation in the context of statutory construction is, specifically in GST laws?
Okay, so let me first tell you about the difference between the literal and strict interpretation, and then I will clarify about the difference between literal, strict, and liberal interpretation. So, literal interpretation means that if the words in a statute are very clear, plain, and unambiguous, and then only one meaning can be inferred, and there is no need to look into the intention or anything else about the law. One Okay, so let me reiterate what I have just discussed. That the literal interpretation means that the law is literally interpreted. That means if the language of the law is very plain, clear, and unambiguous, then only one meaning can be inferred, and courts are bound to give effect to the meaning of that, irrespective of the consequences. But if the and you see, in applying the rule of plain meaning, any hardship or inconvenience caused is inconsequential. But it so happens many a times that the language of the law, the makers of the law, the language is imperfect. It cannot capture all the thought process and the intentions behind the law. So therefore comes the question of the liberal interpretation. So liberal interpretation, the question arises when the language is imperfect, because it is not possible for the lawmaker to conceive all possible situations while framing the law. So many a times the intention of the lawmaker has to be deciphered from various uh, external aids as well as internal aid. For example, parliamentary debates, legislative history, what was the mischief, what was the problem before the law was being formulated, what was the problem which was sought to be remedied, what is the issue which was being dealt with while this particular law was conceived. So all those, you see, aspects, the dictionary meaning, and all those aspects are considered to arrive at the true meaning of the law by looking at the intent of the law. But if the language is uh, absolutely clear and there is no scope of ambiguity, then we have to adopt the plain or the literal interpretation. Now there is a slight difference because these literal interpretation in the strict interpretation, they are often used interchangeably. So strict interpretation, even though it is interpreted strictly, but it does not encompass literalism. Literal meanings means it accepts no implication or inferences whatsoever. Whereas in the interpretation of in the strict interpretation of the law, there is some, joints in the elbow is allowed. Some flexibility is allowed. It is much lesser than the liberal interpretation where we look at the external factors to arrive at the meaning. But in the strict interpretation, if the meaning which is being assigned to a particular word or phrase leads to absurdity and goes totally against the legislative intent, then that can be modified.
So, sir, could we say that while literal interpretation is very narrow,
Yes,
we slowly expand our horizons while we enter the fields of strict interpretation and
correct.
then liberal interpretation? Okay, sir.
Absolutely. Very well, put that we expand the horizon. Literal is very narrow, strict is little beyond that, and liberal is where we look into the external acts. In the strict interpretation, we only look at the internal acts. What is the heading and everything, and we try to decipher the intent of the law from within the framework of the law. We don't go to the parliamentary debates or any other external factors.
Yes, sir. So now that we have an understanding of the broad categories of interpretations that are employed, how would you say that charging provisions or exemption provisions in GST differ in terms of these interpretive approaches?
Okay. So the charging provisions. So first of all, let me tell you that as has been held by the Honorable Supreme Court in Mathuram Agarwal versus State of MP, and another landmark judgment in the case of Govind Saran Ganga Saran versus CST, the there are four essential elements of the charging provision. The subject of the tax means who is going to pay the tax, the the person liable to pay the tax, the rate of the tax, and the computational provision means the measure, the valuation of the, because the rate of the tax has to be applied to some taxable value. If it is an income tax law, then we need to have the income again to which the rate of tax is applied, and who is the person liable to pay tax, and what is the taxable event. Broadly, what event will be there subject to which the tax has to be paid. For example, in the case of central excise law as it existed earlier, manufacture was the taxable event. In the sale tax law, the sale was the taxable event. Now, in the context of GST, the supply of the goods or services are the taxable event. So these are the essential parameters of the charging provision. Now, the law says that the charging provision has to be strictly interpreted. If there is any ambiguity in the charging provision, if any element, if there is any doubt about this, say the rate of tax, that what should be the rate of tax, and there are competing entries, say 5% and 12%, then the benefit should go to the SSE and not to the department. If there is a doubt about whether I am liable to pay tax or not, the subject matter of the tax, then if there is if the doubt is there, then the benefit will go to the SSE. Suppose there is a doubt whether a particular taxable entity is within the purview of the taxation or not, then the benefit has to accrue to the SAC. But in the case of exemption notification, the again it has to be strictly interpreted, but the benefit of doubt will go to the department. If there is a if the SAC clearly falls within the purview or the meaning as it is evident from the bare perusal of the exemption notification, only then the benefit can be given to the SAC. But if it is not there, the benefit goes to the department. Because the logic is that if the exemption is given, then it shifts the fiscal burden to the unexempted class of the taxpayer. So therefore, this concept of strict interpretation of exemption notification is there. While the concept of strict interpretation in the charging provision is that no one can be taxed without the clear-cut authority of the law, which flows from Article 265 of the Constitution.
Sir, now that we have an idea about how exemption notifications are dealt with, a question again arises here. In the case of exemption notifications which are beneficial to the SSCs, would the same strict interpretation be followed, or could we apply a more liberal approach to the same?
So let me tell you that there is a landmark judgment of the Constitution bench of the Honorable Supreme Court in the case of Dilip Kumar and Company, wherein you see this. It was very categorically held that the exemption notifications are to be strictly construed. But subsequently, there is a judgment of the Honorable Supreme Court, not a constitutional bench judgment, but nevertheless a judgment of the Supreme Court. In the case of Government of Kerala versus Mother Superior Adoration Convent, wherein the issue was that a residential building was being constructed for a educational institution. Now the benefit was there for benefit from taxation was there, levy of tax was there. If there was an investment or the construction for the benefit of the educational purpose. So court interpreted that this, the nuns who are there to teach the students, until and unless there is a place of residence for them, they cannot teach properly. So in this context, the court said that if the exemption notification has a specific beneficial purpose, if the exemption notification is, not within particular objective, it is a general exemption notification. So if the exemption notification is given generally, then obviously strict interpretation will be there. But if it is for a particular purpose, for example, promotion of a particular objective, say promotion of education, promotion of economic growth, or any other promotional objective is there behind the notification, then the notification which subserve that particular objective. So here the objective was promotion of the education, and a residential building which was constructed for those nuns was going to subserve the ultimate objective of teaching. So therefore, the court interpreted this notification liberally and gave the benefit to the residential building also.
Yes, sir. Sir, so considering this in mind, could we say that the courts have adopted a two-step approach wherein at the outset the statute is dealt with strictly, and while there are some difficulties that may arise independently in each case, the court adopts a liberal interpretation of the same?
No, two-step approach we cannot link to this beneficial purpose judgment which I just discussed. Two-stage approach means that at the threshold, if we are looking at the condition to be satisfied for being eligible to claim exemption, then it has to be strictly interpreted. But suppose I cross that threshold, I satisfy the condition, and I enter the benefit of the notification. Then suppose there are other procedural conditions to be complied with to avail the benefit of the notification. Then those conditions will be liberally interpreted. So at the threshold, it will be strict interpretation. But once that threshold is crossed, then it will be liberal interpretation.
All right, sir. Um, so now that we have an idea about how courts usually function and the interpretation that is to be taken at different steps, could you give us a few examples wherein these different interpretations have been adopted, singularly, particularly different cases?
So I would give you several examples in the context of GST law, which is a ever evolving new legislation. In the context of GST law, there was a issue whether under section 54 subsection 3, the refund, the rule 89(5) said that the refund is admissible only with respect to inputs. It is not admissible with respect to input services. Now section 54 subsection 3 stated that in case of an inverted tax structure, that means if the rate of tax on your output is less than the rate of tax on input, then I am eligible to claim refund. So it was argued by from the taxpayer's point of view that this inputs should include within its fold input services also. So section 54 does not bar the refund of the input services. But the Honorable Supreme Court interpreted the meaning of the inputs very strictly, saying that refund is equivalent to an exemption because it is reducing the burden of the tax. So therefore, it must be very strictly interpreted. And once the law says that the refund is entitled only if the rate of input is higher than the rate of output. So therefore, the meaning of the input cannot be enlarged to include input services. So this is one example of input services. Now I give you the example of liberal construction in the context of GST law. For example, let us take the example of section 129, where is the penalty of 200% is imposable if the vehicle is caught while transporting the goods without proper documentation in form of e-way bill or invoice and invoice rather. So both e-way bill and invoice must be there while the goods are being transported. Now there are several instances where the SAC has not completely complied with the law. For example, there are two parts of the e-way bill, part A, part B. Part A is filled up, part B is not filled up. So therein, the courts held that I have to look into the intent, whether the intent was to evade the tax. If that intent is missing, then the penalty of 200% is not justified. So there are several instances in the case of transportation of vehicle, transportation of goods without improper documents. For example, e-way will expire without for no fault of the SEC. For example, there is a error in entering the vehicle number in the e-way bill or the invoice, or there are some clerical error or other, which the SEC can demonstrate that it was not with an intent of malified intention, with intent to evade tax. So in those cases, even though there is some discrepancy in the documentation, but the courts have interpreted it liberally and dropped the demand of the penalty. Similarly, section 29, it is very clear and specific that if these are the instances, then, for example, somebody has not filed return for 6 months, then your registration will be cancelled. And there is no mechanism provided in the law to come back to its fold. One may apply for revocation of registration within 1 month, but if one does not do so, then there is no mechanism provided in the law to restore the registration. But the courts have interpreted this particular provision very, very liberally, saying that cancellation of registration is an extreme measure. And if one is allowed to remain outside the fold of the taxation law, then it benefits neither the department nor the SAC, and it also deprives of his right to carry on the trade or business under Article 19(1)(g). It deprives of right to earn livelihood under Article 21, and therefore the courts have time and again have restored the registration by liberally interpreting Section 29. Similarly, in section with respect to Section 75, safari retreat, even though the law has been retrospective amended subsequently, but the court adopted a liberal approach while determining whether a building qualifies as a plant for the benefit of input tax credit. And it said that if the building satisfies the functionality test, that is, means if the building is so necessary for the conduct of the business that the output supply cannot be rendered in the absence of it. For example, in the case of renting, unless there is a building for letting out, one cannot do the business of letting out. So it is an absolute integral to the rendering of the service of letting out. So the court said that if the functionality test is satisfied, then the ITC will be admissible. So like that, there are several instances where the courts have interpreted it strictly or liberally.
Sir, I would just like to ask your opinion. It's more of an opinionated question. Would you say that liberal construction is applied wherein certain gaps were there on the side of the statute in place to
Correct.
fill up said gaps?
You are right. Absolutely right.
All right, sir. I would like to ask if there are any questions.
Sir, I had one question, sir.
Yes, who is there?
Sir, nothing can be read into a
I can't
taxing
hear
statute.
you properly. I mean, you're you're not audible.
Sir, am I audible now?
I mean, please increase the volume of your audio.
Sir, am I audible now?
Still, your voice is feeble. Feeble.
Just a minute.
We could take up the question if you put in the chat box as well.
Sir, am
Yes.
I audible now?
Yes, yes, yes. Fine.
Sir, nothing can be read into a taxing statute. It is a fixed, uh, I mean, it is more or less or a fixed position of law that nothing can be read into a taxing statute. Sir, my question is now the courts, when they liberally interpret, just to say to fill in gaps, as which was
Correct.
mentioned by Abhilash a few minutes before. Sir, is this permissible? Because if you cannot read into a particular taxing statute, then how are you, like, how can you also then exercise the power to fill in the gaps if nothing can be read into a taxing statute, sir?
You see, that nothing can be read into is from the perspective of the charging provision. So, for the charging provision, I have very clearly said that if it is not fitting within the parameters of the law, then no tax can be levied. So, that is very clear. And if there is any ambiguity, the benefit goes to the SAC. But otherwise, in interpreting, there are, you see, various provisions in the law, not just the charging provision. And there are various schemes for the benefit of the SAC. And no lawmaker, howsoever one may try, can conceive all situation and make a perfect law which is unambiguous. So if there is any ambiguity, only then the question of interpretation of the law arises. Unless and until there is an the clarity in the wording which the lawmaker has chosen. There is no question of interpretation. And if there is an ambiguity, courts cannot sit with folded hand and say that we'll do nothing. If some interpretation is leading to absolute absurdity, then the courts are supposed to iron out the creases and uh, give out the intent of the law from various internal aids like the preamble of the law, the long title, the marginal notes, the headings, or the punctuations, provisos, or the external aids like the legislative history, the parliamentary debates, or in the case of taxation law, the memorandum explaining the changes in the law.
Sir, I had one more question, sir.
Yes.
Uh, Sir, although taxing statutes are to be interpreted in a strict manner, but
Yes.
I'll take a very practical example, sir. So now the government had come up with a waiver of the interest and penalty
Right.
for the demands under Section 73.
Right.
Now, it had also issued a circular which was discussed earlier by you, wherein it had restricted that particular benefit of that particular scheme, wherein the demand is due to the delay in filing of the returns.
Right.
Now, if the court is to interpret this particular circular, which mode of interpretation will the courts be choosing, given the fact that it is a circular which is beneficiary, benefiting the assessee in large, but also at the same point the it is flowing from a taxing statute which is to be interpreted strictly. So what will the courts do in such a case, sir?
So you see, the courts have consistently held that if there is a beneficial provision, then the beneficial provision has to be interpreted in favor of the SSE. You have to look at the larger objective. So what is the larger objective? That in the initial period, there was some glitches or other, there was some difficulty which everybody faced in the either in the interpretation of the law or the implementation of the law, something or other. So because of that, court said that there was no intent to evade tax, which falls within the purview of Section 74. So if there was a no intention to defraud the revenue, but the mistake is innocent, which falls within the purview of Section 73, and there is a demand raised against the SAC, then in those cases, if my bona fide is clear, which is obvious from the demand under Section 73 or a notice under Section 73, then the interest and penalty will be left subject to the payment of the tax. So that is the overall objective of the law, to waive off, to condone the errors which are unintentional, which are, not with any intent to defraud the revenue. So any interpretation which attains those objectives will have to be interpreted. And circular which says that you have not filed the return within time limit, so you will not be given the benefit. It will not serve the overall purpose, because the delay in return also initially was because there was some glitch or other in the portal, or some glitch or other at the end of the SSE also, because they were grappling with the implementation of the law.
Uh, I have a question. Can I ask?
Yes, yes, sure.
How does this relate to substantive conditions versus procedural conditions? I will give an example.
Correct.
There is composition scheme, for example, where turnover
Right.
is less than 1.5 crores, or in case of services less than 50 lakhs, you
Ha,
pay a composition tax of 1% or 6%. And
ha,
the
ha.
conditions, essential conditions are two, that you should not avail ITC and you should not collect tax, and your turnover
Correct.
should be below the specified limit. Now,
Correct.
these to me seem to be like substantive conditions,
Correct.
and other conditions like they should intimate it and at the time of registration, or they should before the beginning of financial year. These appear
Correct.
to be like procedural conditions. Now,
Right.
as the GST law is evolving, now there will be some cases of department detecting some non-payment of tax, then issuing show cause notice. Now, in that case, if the particular assessee was otherwise eligible for composition scheme, and after suppose the department has detected, issued show cause notice, and the liability is there, but he's anyway now he's not entitled to ITC because time limits for availing the ITC have elapsed. The department will raise demand at the rate of 18%. Now the assessee wants to pay this previous dues under composition. So the question arises, the department says that you have not obtained registration and you have not intimated this option. So whether in this case assessee can contend that it was a procedural condition and anyway I was not aware, supposing that it is a bona fide case, no mala fide intention. If I had registered, then I would have opted for the composition. But now only because I did not register, that benefit should not be denied. So this is also similar to, it's not exemption, but it's a scheme of the act, as you said it. So in such case, how courts would likely to view, courts are likely to view this situation?
See, if you ask me, it is not just about the substantive consideration versus procedural violation of the law. If you have followed the judgments in the case of transitional credit, whereby you see I am eligible for transition credit, but I could not fill up the form within timeline. There was some problem or other. Then the courts have interpreted that this is filing of the form is merely a procedural condition and the substantive right cannot be taken away because I have satisfied all the conditions of section 140. But your case seems to be that you are mandated to take registration. Suppose you have taken registration beyond the threshold of the 20 lakhs or whatever it is. And after that, you are paying taxes also, but the only default is that you have not intimated. You have paid tax at the rate of 6%. You have discharged your liability, but somehow or other you missed out on filing of that form. Then it can be said that there is a substantively you have complied with the law. You have your intention is very clear that you have paid the tax at the rate of 6%, and therefore substantively you have complied by taking the registration and everything. So you must be eligible. But your case seems to be where you have not even taken the registration. So whether you want to go for the this side or that side, that cannot be deciphered from your mind. Now, by not taking registration after say 4 year, 5 year, the department knocks on your door and you say that I was innocent, I was not aware of the law. So I really don't think that the court will interpret it that way that you are substantively, because the substantive right will arise only if you take the registration and you show your intent. Suppose for 3 months also you have paid the taxes at the rate of 6 months, 3 months. So your intent will can be deciphered from your actions. Without taking any action, how your intention can be deciphered, whether you wanted to avail the benefit of the composition scheme or whether you wanted to pay tax as a regular taxpayer. So I think it's a very really difficult. It will be really difficult case to argue before the court that I have substantively complied. But yes, you have a point. It is not that it is totally unarguable case. One may certainly argue that in any which case I am eligible for this. My turnover is below this, and the scheme of the government allows the benefit of the concessional rate of tax for those whose turnover is less than that, and the department is also not disputing that my turnover is less than that. So uh, I should be given the benefit, and then it will be up to the courts. But I believe that your case is a little weak.
Okay, fine.
Are there any other questions?
I think that LinkedIn Live does not have any option of, participants speaking. I initially joined from there, but then I did not find any option, so I joined via Zoom then.
That LinkedIn Live does not have that facility actually. LinkedIn Live is only broadcasted, so one can participate, and then in the chat box one can ask the question, but not in video form.
Sir, I don't think there are any more questions. Shall we end today's session?
Yes, yes.
Thank you, sir, for today's session.
Thank you.
Thank you, sir.
Thank you so much.